Thanks for attending the Citizens Law School, and thanks, Amy, for presenting. Amy Christenson is a managing partner of Christenson Prezeau, PLLP. She has over 24 years of experience litigating cases in state and federal court involving employment matters, healthcare, and professional liability. She has also appeared on behalf of clients before numerous administrative agencies, including involving matters such as discrimination and retaliation, unemployment insurance, wage and hour, and professional licensing. In addition to her litigation practice, Amy advises a wide variety of large and small employers on legal matters related to performance management, termination, disability accommodations, workplace investigations, personnel policies, employment contracts, overtime compensation, and compliance with state and federal employment laws. Prior to forming Christenson and Prezeau, Amy was the managing partner at Hughes, Kellner, Sullivan, and Alke? Maybe. That's right. Okay, where she worked for 16 years. So Amy, again, thank you for doing this, and apologize to everyone, but we overcame. We overcame. So Amy, go ahead and take it away.
All right, thank you, Brian. And again, my apologies. I will move through this fairly rapidly just to make up for lost time, and I want to make sure I leave time for questions at the end. So I am a small business owner and I practice mostly employment law. So my presentation today is going to cover employment law for a small business owner. It will be heavy on the employment law because that is my primary area of practice, and hopefully there will be some takeaways for folks who are dealing with employment related issues or have questions along those lines. So here are the topics we're going to cover today. I'm going to start with hiring issues. And typically when folks are looking to bring somebody on, they're trying to figure out, should they be an independent contractor or should they be an employee? There's a lot of questions surrounding that, so we'll talk that through. We'll also talk about, in an interview process, information that you can get and information that you shouldn't get. Once you bring somebody on, then you start looking at issues potentially related to discipline and performance management. So we'll spend some time talking about the rules that apply to those situations, and then also what tools are available to employers to manage employee performance. We'll touch on some discrimination issues just at a high level, and then I'll leave time for questions. All of these topics are definitely areas that could be covered in an hour plus long presentation all by themselves. So again, this is pretty high level overview, but if you have questions, I'm happy to answer them at the end. Okay, so hiring. There is some, reasons why people would want to bring somebody on as an independent contractor. There are some tax benefits. There are some, reasons why you might not want to make somebody an employee, just in terms of potential risk. But in order to bring somebody on as an independent contractor, it isn't just as simple as deciding, well, I think they'll be an independent contractor versus an employee. You actually have to satisfy some tests. There's a two-part test in Montana, and the first part involves evidence of control. And what that means is the hiring agent should not exert an excessive amount of control over the contractor. The contractor has to control the details of how services are to be performed. And there's a lot of individual factors that go into play in determining who has control. And in order to qualify as an independent contractor, you have to tip the scales, not just, a 51-49 tip. You got to tip them a lot to make sure that this test is satisfied. So you try to hit as many of these factors that demonstrate evidence of control as you can. So some of these would be how the person is paid. If you want to demonstrate an independent contractor relationship, then the hiring agent should not pay a person based on time. They should pay them based on completed project. They should also require the contractor to furnish their own tools or materials. There shouldn't need to be a lot of training about how to do the job, and the contractor should control hiring of their subordinates. So those are just a few of the factors that can demonstrate evidence of control. The other part of the two-part test is that the contractor has to have an independently established business. And again, there's a lot of factors that go into making this determination, and you want to hit as many of these factors as possible to demonstrate an independent contractor relationship. So some of these are: the contractor has a separate place of business. They're not housed in the hiring agent's location. They're paid through an invoice rather than a timesheet. They do work for others, not just your small business. They advertise their business. They file independent tax returns, and typically there's a written contract. So again, just a smattering of these criteria that can help establish or demonstrate that the contractor has an independently established business. One of the other key factors in proving an independent contractor relationship is an independent contractor exemption certificate. These are available from the Montana Department of Labor and Industry. And it isn't as simple as going down and saying, hey, I want one of these. You have to fill out an affidavit. The contractor does. They have to fill out an affidavit that asks these questions about who has the control and do you have an independently established business. So you have to answer a lot of questions to demonstrate that both of those criteria are met. And if they are met, then that certificate provides it creates a conclusive presumption of independent contractor status. It's pretty powerful. It isn't bulletproof because it can still be overcome by proof of fraud. So there was a case in Montana not too long ago where the individual who was hired said, I'm an employee, I'm not an independent contractor. And the employer said, well, hey, I've got your independent contractor exemption certificate right here. What do you mean you're an employee? Well, it turned out that the employer had filled out the affidavit and obtained the independent contractor exemption certificate itself, which the court said that was fraudulent because the individual didn't obtain that certificate. So in that situation, the conclusive presumption of independent contractor status was rebutted. I have a picture on this slide of paintbrushes and paint cans because the way that I think about independent contractor status, one of the purest examples is a house painter. It's somebody who bids on a project. They come in with their paintbrushes. They might be told the color. They might be told kind of where, how to paint, which color to paint the trim and which to paint the body of the house. But the painter is the one who decides on the means and methods for getting the job done. The house owner is not going in and saying, you're using the wrong brush and you need to use a roller here. That would be evidence of control. And if you're hiring an independent contractor, the contractor controls the means and methods. So house painter finishes the job, gets paid, goes on to the next house. So that's just a very simple example of how that independent contractor relationship works when you meet the criteria. Okay. It is really important to hire correctly, either as an employee or as an independent contractor, because the consequences for doing it wrong are steep. If you hire somebody and you think they're an independent contractor, but you haven't met the criteria, you could end up being an uninsured employer because you haven't bought workers' comp insurance because they're an independent contractor. If they are deemed to be an employee and they have an accident and you don't have coverage, that's a big problem. You can also end up in a situation where there's unpaid overtime. The employee, you think it's a contractor, so you're not keeping track of time. The employee thinks they're an employee. They are keeping track of their time, and they're going to have better records than you because of that. And you may owe them overtime if they've been working more than 40 hours in a week. There's also the risk of federal and state withholding and employment taxes, because if they're an independent contractor, you haven't been withholding those things. If they're determined to be an employee and you haven't been withholding those things, it's problematic. You are also at risk of wrongful discharge claims if you part ways and you don't have good cause. We'll talk about that. And it's also possible that the employee, if they're deemed to be an employee, would be entitled to back benefits. And the big risk there is health insurance. If they should have been entitled to health insurance and they didn't get it, and they have some, you know, they have a heart attack, or they have something that requires major surgery, there is risk there. So really, really important to make the correct determination at the outset about whether you're bringing somebody on as an employee or as an independent contractor. Okay, so let's assume that you've made that decision and you decided to bring the person on as an employee. There are questions that you can ask during the pre-offer, so this is the interview stage, and there are questions you should not ask. So the questions that you can ask are things like, can you perform the job functions? Can you describe how you would do the job? Can you satisfy the attendance requirements? Describe your qualifications. So those are all, you know, fairly basic interview questions, right? Questions you should not ask. What's your workers' comp history? I see that on occasion on applications. I think it probably comes up sometimes in interviews. It's definitely off limits. Will you need a reasonable accommodation to do this job? Not something that you should elicit information about during the interview. Really, what you want to be careful doing when you're asking questions is not gathering information about a disability. It's just not information you want to have at this stage of the process if you can help it. Post-offer, so after you give somebody an offer, and it can be a contingent offer, you know, you have to pass a background check, you have to pass a medical exam, you can ask disability-related questions, and you can have them get a medical examination with some conditions. The job offer has to be real. It can't be that you interviewed 25 people for 2 jobs, you gave everybody a job offer, and now they all have to go through that process. That's probably not real. You can make job offers to more people than positions that you have, but it's got to be, they still have to be real. You also have to require all employees entering into the same job category to go through those same processes. You can't just say, okay, we're gonna hire 5 people, but just this one has to go through the medical exam. Everybody would have to. The employer also has to maintain medical information in a separate file. It cannot be in the personnel file. It has to be kept separately, and it has to be secure. So it's not someplace where everybody has access to it. And it's also important to be careful, because if you are having people undergo medical examinations, or you're asking disability-related questions, you now have in your possession medical information. And if your decision is to withdraw the job offer for some reason, it could be a background check. It could be something that comes back where you're like, yeah, this person has an embezzlement charge, and this is an accounting position. We're not going to hire them for that reason. But they've also just shared with us that they have this chronic medical condition. So now, you know, you're kind of, there is a risk that when you withdraw the job offer, they could view it as being based on a medical condition. So you really want to make sure that if you're making a decision to withdraw a job offer after you have medical information, you are confident that the decision is job related and consistent with business necessity. Okay, so let's say you've hired the person, you are ready to get them launched. Let's talk about some of the rules that apply to the employment relationship and tools that you can use to manage performance. Okay, so one of the most significant rules in Montana is the Wrongful Discharge from Employment Act. We're the only state in the country that has this statute. A lot of other states have similar rules. We just have them all packaged into this statute, which in a lot of ways is helpful. It helps employers know what the rules are, helps employees know the same thing, so everybody's operating from the same playbook. Under the Wrongful Discharge from Employment Act, an employer has to have good cause to terminate an employee outside of the probationary period. And good cause there's a lot of different ways to demonstrate good cause. One way is to show a failure to satisfactorily perform job duties. That's just somebody who's not getting the job done. Disruption of business operations, that could be any number of things. It could be an employee, let's say you're in retail and the employee is rude to customers, swears at them and chases them off the property. Well, they're disrupting your business operations. Or, there's a lot of different ways that can present itself. Material or repeated violation of an express written personnel policy constitutes good cause for termination. And then other legitimate business reason determined by the employer while exercising reasonable business judgment. In the last legislative session, this particular statute was changed significantly, and this is one of the changes that was made. The statute used to just be other legitimate business reason, and now it has it's been expanded a little bit, I think, to tip the balance in favor of employers to allow them to essentially determine what that other legitimate business reason is, as long as they're exercising reasonable business judgment. It gives the employer a lot more latitude to make that judgment call. So that is good cause. When you're dealing with managers, the situation is a little bit different. You still have to have good cause to terminate outside the probationary period, but the bar is quite a bit lower. This is another area where the statute was changed, and it added to the statute some language from cases that said when you're dealing with a manager, the employer has greater discretion to decide who they want to have run their business, their organization. And so you have to be able to trust that person, and you have to be able to know that they're going to do what you ask them to do. And so if that is going south, then the employer has greater latitude to determine that that situation is not workable and to terminate. And so the good cause that they have to develop is not quite at the same level as it is with other kinds of employees. Other rules that employers have to follow are discrimination laws at both the state and federal level. Depending on the size of the employer, some of those federal laws won't apply. The state law will apply to everybody. And by and large, the state and the federal law are pretty much the same when it comes to discrimination issues. The only difference in this list of protected classes between state and federal law is that Montana protects marital status and federal law does not. So marital status is who you're married to, as well as the status of being married or not married. If you are making an employment decision related to somebody who's in a protected class, you want to make sure that you have legitimate non-discriminatory reasons for the employment action. And at the end of the day, legitimate non-discriminatory reasons are about the same thing as good cause. You just have to have really justifiable reasons for terminating someone's employment, whether it's because you're complying with the discrimination laws or the Wrongful Discharge Act. The other thing to keep an eye on is the potential for retaliation claims. And those types of claims arise if you have an employee who engages in protected activity and then experiences an adverse employment action, and there's some connection between those two things. So protected activity would be they complain about sexual harassment, or they are a witness and are interviewed in a sexual harassment claim and they report what they saw. So they participate in an investigation like that. Or they complain about workplace safety, something like that, and then something happens to them. They get a bad performance evaluation. They get demoted. They get fired. They get a written warning. They get disciplined in some ways. If the employee can demonstrate a connection between those two things, then they can establish a retaliation claim. So something to be aware of. Personnel policies are another category of rules for employers to follow. The first several of these are ones that I think are really nice to have when I'm advising clients. I really like it when they have these policies, because it's just nice to be able to point to a policy when you're trying to address a performance issue. So standards of conduct. It's great to have a policy that says, employees have to be nice to each other. They have to speak respectfully and professionally and courteously to their coworkers, supervisors, and customers. Because if that's not happening, you can say, hey, you violated this policy. That's just one standard of conduct. There's a lot of other ones. Don't steal, don't take our property without asking. There's, you can put a lot of things in there. A lot of them are self-evident, don't get me wrong, but it is nice to be able to point to a policy if you have to address that kind of behavior with an employee. Authorization for overtime is another nice policy to have. Requiring employees to get authorization in advance of working the overtime, because it just makes it really clear. If they work the overtime, you still have to pay them, but you can discipline them for violating the policy if you've got one. Attendance and punctuality. Every employer should have one of these policies, because they come, issues with attendance and punctuality happen all the time. So it's nice to be able to point to what your expectations are and that have been shared with your employees. Electronic resource use is another really good one to have, just to let employees know that here are the parameters, here's what you can and can't do with the resources that we provide, and here's when we might take a look at what you've been doing, because we're worried about whether you violated policies or whether you're, on the internet, on, eBay all day long selling your own private crocheted scarves, whatever you're doing. It's nice to be able to take a look at that using your electronic resource use policy. Drug and alcohol use is another policy that comes up every once in a while. It's also nice to have one of those. A harassment policy is helpful, both so that employees know what harassment is and how to report it, and then what the employer will do when that happens. A discipline policy is helpful to, provide a list of what your disciplinary options are. Grievance policies are especially important because under the Wrongful Discharge Act, if you give an employee a grievance within 14 days after they leave and they don't file a grievance, you have an automatic defense to a wrongful discharge claim. Really, really powerful defense. So it's really nice to have one of those policies in place. It's also important to know, this is one of the more recent changes to the Wrongful Discharge Act. If the employer has a material violation of a written policy that deprives the employee of a fair and reasonable opportunity to stay in the job, that amounts to a wrongful discharge. And that's true even if you have good cause for termination. So this can be a really problematic thing for an employer if they're not following their policies as part of the termination. So an example would be, you have a discipline policy that says all terminations have to be approved by the president of the company. And the vice president is the one who makes this decision, and you didn't get the president's approval. Well, that possibly deprives the employee of a fair and reasonable opportunity to stay in the job. And so even if the employee was fired for good reason, you still violated your written policy in the course of the termination, and so it could still be a wrongful discharge. So good idea to check policies before a termination decision is made. Okay, so talk about the rules. What tools does the employer have when managing employees? One of the biggest, most useful tools is the new hire probationary period, which comes from the Wrongful Discharge Act. This is the only time during employment when the employee can be terminated without good cause. It's essentially Montana's version of at-will employment. Under the Wrongful Discharge Act, if an employer does not establish a probationary period, there's a 12-month default probationary period that is applied automatically. So they could, an employer can establish a 6-month probationary period or a 9-month probationary period. I typically recommend to clients that they do 12 months because it gives you an opportunity to go through every cycle that you have in a year, so depending on the employer, let's say you're an accounting firm. It's important to go through tax season. It's important to go through year end. It's important to go through, some of those other parts of the year where you need to see how somebody's going to perform. So 12 months is nice. The 12 months can be extended to a total of 18 months. I've had some questions about, well, can you just apply an 18-month probationary period? That question hasn't been answered. I don't recommend doing it. And honestly, 12 months, I haven't seen a situation where an employer could not make a judgment call at the end of 12 months. 12 months is just it's enough time to assess whether someone is going to be a long-term employee, or at least where you're comfortable with them sticking around for a while. So I don't typically recommend starting with longer than 12 months. The probationary period can be paused if the employee is gone for 5 or more consecutive days other than vacation or holidays. So for example, the employee starts, they've been around for 5 months, and then they're in a bad accident, and it takes them 2 months to recover. Then if that happens, you can stop the probationary period for those 2 months and extend it at the end so that you get the full benefit of the entire probationary period, so that you can evaluate the employee over the entirety of that time. So that's one of the nice changes from the most recent legislative session. So probationary period is really a nice tool if the employee is just not a good fit. That's a situation where, they can't seem to get to work on time. Their work product is not great, and they aren't fitting in well with your coworkers. There's some friction, and everything is just feeling a little bit off. Probationary period is a nice way to part ways with limited risk. But it's not completely without risk. You really want to keep an eye on whether or not the person that you're terminating is a member of a protected class. Or they've made recent complaints about the workplace. And that is because the probationary period will protect against a claim under the Wrongful Discharge Act, but it doesn't apply to terminations that might be based on discriminatory or retaliatory reasons. So if you say, I'm terminating you without cause, and it's a pregnant woman, then she might say, well, I think you're terminating me for a discriminatory reason. And you can say, but you're probationary. Well, it doesn't matter. That's not a defense. And unfortunately, you just said you didn't have cause. So now you've walked yourself out of a potential argument about what those reasons are. So it can be really, you just want to be aware that that probationary period is a powerful defense, but it's not bulletproof. Okay, performance evaluations are another tool that are available to small businesses to evaluate performance. Typically, a formal evaluation once a year is a really good idea. It provides good feedback and makes sure that employers and employees are on the same page. Of course, provide more feedback informally as the need presents itself. And it's also important in those performance evaluations that the feedback be constructive and not sugar-coated. Some managers they're just conflict averse, and they don't want to give an employee bad news. And so when they give the feedback, it's satisfactory or above, and they don't really highlight any of the problems, and everything seems hunky-dory just because they don't want to have that difficult conversation. Nothing wrong with that. It's just that it creates some fairly serious problems down the road. If you have a new supervisor who's trying to address performance issues and you have this sugar-coated performance evaluation, it makes it harder. It also makes it harder for anybody in the business to take further disciplinary action if there's a positive performance evaluation, even especially if it's not accurate. It kind of sets you back a little bit. So constructive, objective feedback is really critical. That performance evaluation can also help create a foundation for later discipline if that's necessary, because it puts the employee on notice of what the concerns are about their performance and lets them know what they need to do going forward. Okay, so disciplinary action, more tools that an employer has at its disposal. Disciplinary action can be progressive, but it doesn't have to be. It kind of depends on what conduct or what performance you're trying to target, whether it's a chronic problem or a major offense. So chronic tardiness versus embezzlement, totally different approach, right? Progressive discipline works really well for underperformance. Somebody who just, there's accuracy issues, attention to detail problems, those kinds of chronic performance deficiencies. They're just not getting it. Absenteeism, tardiness issues, those kinds of issues that happen a lot, and you just have to keep working at them. It helps to start verbal warning, written warning, written warning. You're kind of building in seriousness. It's one issue that I want to mention here on this disciplinary action, though. It's really important to not have a strict progressive discipline policy. You don't want a policy that says, your first infraction, you get a verbal warning. Your second one, you get a written warning. And your third one, you're terminated. Because if the first time somebody does something wrong is when they steal from you or they punch somebody, you want to fire them. You don't want to give them a verbal warning. So you want to have a policy that gives you that latitude, that presents tools, that gives you, the employer, the ability to choose the correct tool to address the problem that's presented. Okay. Discrimination issues. Again, big topics, high level. I'm going to give you just kind of an overview of these areas. And these two, disability and sexual harassment / hostile work environment, these are the ones that I see most commonly in my practice, both from the standpoint of advising employers and also from a litigation perspective. So let's start with disability discrimination. So this bullet is the law in a nutshell. And all of these highlighted terms have significant meaning and thousands of cases interpreting each of them. But the general rule is an employer has to provide a reasonable accommodation to a qualified individual with a disability unless it would create an undue hardship. So reasonable accommodation is some sort of measure that helps the employee perform the essential functions of their job. Sometimes that reasonable accommodation is super easy to figure out. You've got an employee in a wheelchair and they need a desk that is tall enough so their wheelchair can slide under it. That's an accommodation, and it's pretty straightforward, and the employer and the employee can talk it through. Other accommodations are less simple to figure out. Sometimes you have to get medical information to understand what the employee needs, and that's especially true if the disability is a mental health issue or other kinds of physical issues that are not visible, like back issues are often hard to figure out, and you need medical information to deal with those and figure out what the restrictions are. A qualified individual is somebody who both has the qualifications like certificates, degrees, that sort of thing, and also is able to do the job physically, right? So a qualified person, let's say they want to be a lawyer, but they have a learning disability and they can't get a law degree, they're not qualified because you can't practice law without a law degree or without passing the bar. Another example would be, somebody with a vision impairment who wants to be a school bus driver. They're not going to be qualified to do that job. So that's the qualified individual piece. Disability piece, disability is a substantial impairment that affects a major life activity. Again, terms of art that have significant meaning and lots of case law interpreting them. But in essence, the disability bar is pretty low. There's things that aren't going to qualify, like a cold is not going to qualify. The flu is not going to qualify. But, chronic medical conditions will typically qualify. There's a lot of stuff will. I don't typically challenge whether somebody has a disability unless it's there's a really strong argument that they don't, because the law just essentially wants you to get past that hurdle and start talking about accommodations. You don't have to provide a reasonable accommodation if it would cause an undue hardship. And that's really, again, very fact specific. Sometimes it's financial, depending on the size of the employer. Sometimes it's an impact on another employee. If it's like, you have 3 jobs and the accommodation that somebody needs is to kick that person out of a job, that you wouldn't have to do. That's an undue hardship. So that term also has significant meaning in the law. The identification of the reasonable accommodation comes through an interactive process, which is really a conversation between the employer and the employee to figure out, what can we do here? What do you need, employee? And what can we, employer, offer? And so through that dialogue, the theory is that you can come to an appropriate accommodation. You want to document the interactive process because that is an important part of an employer's obligation to that employee. Okay, hostile work environment and harassment. I refer to this as big H, hostile work environment harassment, because we're talking about harassment that's based on membership in a protected class. And it is defined as conduct that unreasonably interferes with work performance or creates an intimidating, hostile, or offensive working environment. It's a fairly high bar, but again, has to be based on membership in a protected class, as distinguished from what I call small h, hostile work environment harassment, which is kind of a situation where you're not getting along with your supervisor who micromanages you. You're not getting along with a coworker because you just broke up with the coworker's boy or brother. There's those kinds of situations where there's workplace conflict, but it's not based on membership in a protected class. So it's a different kind of harassment. We're going to talk about the kind that involves protected classes. So when you're talking about big H harassment, the harasser's intent is irrelevant. I like this picture because it shows both the harasser and the recipient. And the harasser, thinking, hey, I'm being helpful, I'm showing her a couple things. What he thinks, however, is irrelevant, because the conduct and whether it's determined to be harassment is evaluated from the recipient's perspective. So here you can see she's uncomfortable. She does not like how close he is to her. She doesn't like the physical contact from him. It's making her really uncomfortable. The evaluation of whether the conduct amounts to harassment is looked at from a reasonable person standard, which who knows what that means. But what it doesn't mean is like a prickly person standard. So somebody who's, kind of unreasonable, I guess I would say, somebody who's super, super sensitive. It's not that person. It's a reasonable person and how they would feel that. So how would most people feel about someone coming and putting their arm around them and being very much in their personal space, leaning over their laptop? A reasonable person is going to find that to be uncomfortable. So how are hostile work environments created? Not uncommon for a relationship that starts as consensual to end and one person continues to pursue the other. Can involve same-sex sexual harassment. And then there's also run-of-the-mill sorts of things that develop into a hostile work environment. These ones are super common. Comments about clothes or looks, like, wow, you look great in those jeans. Propositions, like back rubs, kind of unwanted touching, where you have somebody who seems to always have a reason to be in very close proximity, touching your arm, touching the small of your back, those kinds of things. Repeated or inappropriate questions about personal life, all of these involve boundary issues, whether it's physical boundaries or boundaries, just personal boundaries in terms of relationships, trying to get more intimate information than you would otherwise obtain in a professional setting. All of those things can create a hostile work environment. And hostile work environments can be created in all sorts of environment. It can happen in the office, obviously, because people are in contact, but it can also happen in off-duty settings. And these are really, really common. Holiday parties. I get calls every year. It's very busy around the holidays because people are getting together at parties. Typically, there's alcohol involved, and people are less inhibited. You know, they're less formal. They're more likely to just engage in conduct that they wouldn't when they're in a more formal office environment. Conferences are another place where that happens a lot. And texting is also another means by which a hostile work environment can be created, and that can happen off duty. But if the people are texting each other because they have a work relationship and the texting veers into harassment, then that can create liability. Hostile work environment can also be created by a number of different people. Obviously, coworkers, supervisors, but also clients and vendors. So, you know, the UPS driver who comes in and greets the receptionist and, you know, is constantly hitting on her, interpersonal space, all of those things. If the employer knows about it, doesn't act, that can be problematic. Okay, how does the employer respond to harassment? Let's say an employee expresses concerns about a coworker, a customer, something like, I feel like I am being harassed based on my religion, my race, my sex, any of those things. The obligation of the employer is to prevent and correct harassment. So what does that look like? Starts with a policy. So I mentioned that earlier in the tools, that a policy is a really helpful tool to have, because that is a big help when it comes to preventing harassment. It explains what harassment is, helps employees understand how to report it, what will happen when they do, what protections they have from retaliation. So having a policy, training people on it, helping them understand what it is and what to do if they experience it, see it, observe it, hear it, whatever. And then investigate, figure out what happened. And that can be internal, it can be external. That's a whole different topic that is more than an hour, but the employer has an obligation to take action when it learns that there is potential harassment. And part of that action is investigating to try to figure out what is going on. And then if that harassment substantiated, then they have to take action. And that's the correcting part. And it's action that's commensurate with what's going on. Sometimes it's just additional training. It's an awareness thing. I mean, and that is not uncommon, that people are just not aware. And it's strange in this day and age, but some people are just not aware of how their conduct is being perceived by others. Sometimes that requires just a level of training. Sometimes it requires termination because it's really serious conduct. Sometimes it's a warning. You just really have to look at the specific facts involved and make the judgment from there. Okay, I flew through that, and I have some time for questions. Okay. What are all the protected classes, and does political affiliation count? That is a really good question, especially this time of year. Under the Montana Human Rights Act, which applies to public and private employers, political ideas or beliefs is not protected. So within a private employment setting, that is not among the protected classes. For public employers who are subject to the Governmental Code of Fair Practices, there is a category of political ideas that is protected. So somebody cannot be subject to discrimination for their political ideas. And I actually have a case that is set for trial next year that involves political ideas, a former public employee who was terminated, and his alleged public political discrimination is essentially. So that's kind of how that splits out. There's a question about, are employees allowed to discuss wages with coworkers without fear of retaliation? And that is also a really good question because I think it's very misunderstood. And the short answer is yes. And that answer comes from the National Labor Relations Act, which typically applies to unionized workplaces, but it's one of the rules that applies to non-union workplaces as well. And employers, even if they don't have a union in the workplace, have the ability to discuss work conditions, so terms and conditions of employment. So they can talk about their wages with each other, and that is considered concerted activity. So the employer cannot prohibit that and cannot discipline them for that. I frequently see policies that prohibit that, but those are not lawful. So I don't, it makes employers uncomfortable to have employees discussing wages because sometimes that creates morale issues and conflict. But it's also a way that employees learn whether their colleague in a different protected class or who's not in a protected class is making more than them. So it actually, I think, from a public policy standpoint makes sense, but it does create some discomfort for employers. Okay, next question. I have volunteers and employees, so I have to have two separate policies. What should we do? What should we look out for in working with volunteers? So I have clients that have separate policies for volunteers and employees, which I like. I like to have those separated because you don't want to give volunteers the impression that they're employees. You don't want to kind of create any kind of arguments or misunderstandings or inadvertently deem them to be an employee by applying the same exact policies to them. So it's better to have a separate policy handbook. There are going to be some policies that will overlap. Like, I think you should have your harassment policy applicable to volunteers because you don't want your volunteers being harassed and you don't want your volunteers harassing other people. So that's one policy that I would have in both places, maybe modify just a little bit, but you definitely want your volunteers to be squarely in the volunteer category and employees in the employee category, and keep them separated so you don't inadvertently create a situation where a volunteer could say, well, we're subject to the same rules, we're doing some of the same work, I think I should be paid. So it's just one way to kind of guard against that. You can't, is a discipline policy a good idea for volunteers? I don't think you necessarily need a discipline policy because you can always just tell the volunteer that they can't volunteer anymore. And there really is very low risk in doing that. It's different from an employee, right? Because you have to have good cause to terminate an employee outside of the probationary period. So you want to have a formal discipline policy for them. But with volunteers, if if they're not getting along with people or they're creating problems, you can just say, you're not welcome to return, and they can't sue you for wrongful discharge. So I don't know that it's necessary to have a discipline policy. And I also question whether it's wise to have a discipline policy, just because it's one of those areas where it starts to make them look more like employees than volunteers. Any other questions? There's one question here. Do you have an example of how a grievance policy would work? I can give you some broad strokes there about it. Grievance policies, the statute doesn't require any particular process to be followed. So the employer really has quite a bit of latitude in crafting a grievance policy that works for them. I think with smaller employers, a 1 or 2-step grievance policy works well. For larger employers, you might have 3-ish steps in the grievance procedure, but I think that the simpler, the better. I think some of the things that are important in the grievance policy are deadlines. How soon does somebody need to file a grievance after a grievable event occurs? Definitions. What will you allow to be grieved? Is it just termination? Is it just disciplinary action? Is it everything? Is it wide open? I'm not a huge fan of the wide open kinds, because every once in a while you get an employee who grieves everything, and that just ends up being more work for everybody. And so the middle ground that I have come to like over the years is the kind of grievance procedure that allows somebody to grieve disciplinary action. The upside is it's really well defined and you don't get an unusual number of grievances. The downside is you probably miss some of those issues that you want people to bring forward. So it's kind of finding the right balance there in terms of what works best for your organization, in terms of how complicated, how simple, and what all you want people to be able to grieve. Okay, well, I appreciate everybody attending. I hope that this was helpful. I know it was fast and went over a lot of information, but hopefully there was information in there that was useful and that can help you in your small business. So thanks very much.
Amy, thank you very much. Joe, thanks from the State Bar getting us tech sorted out to begin with. And thanks, Anna Conley, who's the chair of the Law Related Education Committee. Next week is going to be criminal law with myself and Jen Clark from the U.S. Attorney's Office. We'll have tribal law on November 9th, family law November 16th, and landlord-tenant on November 30th. So everybody, thank you very much for being here and have a good night.